We are now recording.
So the current time is 10:04 a.m. And we're calling this meeting to order. Janelle, can we do a roll call?
Sure. 1 moment. Alano,
Present.
Bennett,
Present.
Jenkins,
Present.
McGlory is absent. Ruckert, absent. Sermitis,
Present.
we have quorum.
All right, some meeting reminders before we begin everything. As required by the Bagley-Keene Act, Open Meeting Act, members are to appear visibly on camera during teleconference meetings, except if a member is unable to appear by video due to connectivity issues. We ask that any members who are present with their cameras off state their name and reasons for not being on camera. If a member joins the meeting after roll call, they should raise their hand virtually to notify myself and the public that you're present. If your camera is off, you should provide an explanation. Members should also raise their hands when leaving and returning to the meeting if they will be absent for more than 5 minutes. Next, we're going to call for a public comment. But before we begin that, I'd like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to the items that are on the agenda or be related to matters that are within the jurisdiction of this agency. Specifically, the committee exercises oversight on program. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. We have read and received all the written public comments, and thank you for any of those. To facilitate the hearing, to allow as many members of the public as possible, we encourage you not to repeat points that were made by previous speakers. And as chair of the CBLS, I'm going to exercise the option to limit each speaker's time to 2 minutes. For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon, and it should appear at the bottom center of your screen. If you wish to address the committee, please click on the hand icon now, and the committee coordinator will call on you in the order that hands are raised. For those participating by phone, you may virtually raise your hand by pressing *9. That's the star key, the number 9. And again, doing so will alert the staff that you would like to make a comment, and the committee coordinator will call on you and open your microphone so that you can address the committee. For those that are participating from a noticed location, please alert the committee member or the State Bar staff member present in the room that you would like to make a comment. Staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. The timer's 2-minute countdown will begin as soon as you start your comment, and the timer will flash throughout the final 10 seconds. Do we have anyone that wishes to make comments?
I see no raised hands.
Okay. Okay, given that there are no raised hands and it doesn't appear that there's anyone present publicly that wishes to make comment, we're going to move on to the first item. And I'm just going to go over a few things. This is the second CBLS meeting of the State Bar year. The appointment period for the board closes on March 31st. And we've had 2 applicants submit applications for 2 available seats on the CBLS. I stepped down as chair this year, and a chair and vice chair will be recommended for 1-year terms. So the next thing I'm going to do is ask everyone to take a moment, if you haven't, to review the minutes and of the December 12th, 2025 CBLS meeting. And some of you may have reviewed that beforehand, but if not, just take a moment. Does anyone have any questions or comments on the Board of Specialization open meeting minutes of December 12th, 2025? Okay, there being no questions or comments,
I
like to
see
call for,
Pamela has her hand raised.
oh, no, I didn't see.
I'm sorry. I was going to initially ask if it was okay to make a comment. I just had a few. Just wanted to know if there was any follow-up regarding the comments, the public comments rather that Mark Lester made, and specifically the last paragraph regarding accountability of the specialization fees, repayment of borrowed funds, as CVL says authority if those issues were expounded upon, um, and how that ended. Let me see. I think that was the only. And then one more comment on page 3, just regarding further resolved. My comment or question there was, does registration determine the need? There was a conversation around accepting new applications. So those were just my observations.
Pamela, are you asking if there was a discussion about the public comment that was received?
Yes, if there was going to be further investigation or consideration of the points that he made.
There hasn't been an agendized discussion. As far as the fees specifically, I would just point perhaps to I believe the November Board of Trustees meeting, in which the fees for a number of admissions programs, and that includes the exam-related legal specialist program fees, were reviewed, and there were some changes to the fees, and I'll point to that because part of the materials that was provided for that fee discussion was an assessment of the revenue and expenses related to the exam side of the legal specialist program, and it included several proposals for fee changes, break-even fee amount. So that would probably be some of the most up-to-date information about at least part of the program. Again, that's the exam side that impacts the Office of Admissions. So yeah, I just wanted to offer the audience and our members here that material was considered by the board and does exist. Yeah.
All right, thank you.
There anything else? Okay. Does anyone wish to make a motion to approve the minutes?
I move to approve the minutes.
Is there a second?
I'll second it, Damon.
And can we ask the
I'll go ahead and take a roll call vote.
yeah.
Alano,
Aye.
Bennett,
Yes.
Jenkins,
Approve.
Glory is absent. Ruckert is absent. Sermitis,
Approve.
with 4 ayes and 0 nays, the motion passes.
So we're going to move on to the next item, which is the staff report. And first is recent developments regarding the legal specialization program and the state bar. And I'm going to turn that over to Cody.
Thank you, George. Yeah, just a quick set of updates related to the program. First, I want to point out the release of results for the October 2025 legal specialist examination. The date for that release was pushed back to March 23rd. We had we were re-engaging our psychometrician vendor for this exam. That caused some delays. Also, there were some of our graders who themselves are legal specialists and working professionals who requested more time to finish reviewing the essays in their sets. We notified all of our test takers, I believe about a week and a half or 2 weeks ago, letting them know that the date would be changing and that the release of results would be occurring the week of March 23rd, so next week. And we let them know that we would be notifying them by email upon the release of results. And it looks like, based on the last update from our team, we're on track for a release on Friday. And so we'll be notifying our test takers on Friday. As soon as the release of results is available, they'll receive that letter. They'll also receive the bulletin that gives them information about next steps for either those who were successful or those who are unsuccessful. So we'll be in communication with test takers. We'll let members know as well or as soon as that goes out. Second, I wanted to give an update following our December meeting. We had a very interesting discussion about the future of the Admiralty and Maritime Law specialty area, and CBLS ultimately adopted a resolution for staff to take the necessary steps to close the program to new applicants, essentially closing access to the exam. And we had informed members during that staff discussion and the staff report that there was some ongoing research about kind of what steps were necessary to implement that policy. We've been in discussion with counsel, and we do think that it actually may require an amendment to either the rules or standards related to the Admiralty and Maritime Law specialty area. So we'll likely be bringing back a second discussion to CBLS to discuss any further action that's necessary to implement that, perhaps some proposed rule amendments or standards language amendments. I don't have a timeline for members yet. We want to make sure that we're really doing this the right way, but we'll keep you informed and just anticipate a future discussion on that. And then lastly, just want to keep members up to date about some of the work that starts here but works its way to the Board of Trustees. We had public comment for the standards on the new privacy law specialty area that CBLS worked very hard on, close at the end of last year. The public comment has not yet been considered by the Board of Trustees, so we anticipate that will be part of a future discussion. The next board meeting, I believe, is in May, and so it could be as early as then. And so that's something that's pending board approval. Once that occurs, then we'll have the tasks of actually implementing this program. So we're really looking forward to kind of getting that signed off on. And then lastly, this is a kind of a newer update that's come to our attention over the last few weeks. Several years ago, CBLS worked on updating a number of the standards related to the different specialty area programs. I think it's come to our attention that those standards were adopted here by CBLS, but were never adopted per se, I guess, or updated in our state bar rules. All of the standards related to the legal specialty areas are appendices to our state bar rules, and those were never implemented by the board. And so we are working, Mia and I and some members of our team, on taking the work that CBLS had approved and kind of formally getting that published through those channels. So that's also something we anticipate is likely going to be part of the May agenda or very soon meeting. Yeah, happy to take any questions. Okay, well, thank you all.
Thank you, Cody. So we're going to move on to the next item, which is the action on the 2026 California Board of Legal Specialization Work Plan. And I'm going to turn that over to Adrian.
Sure. Let me just pull up the work plan. So today, the 2026 CBLS work plan is being presented for review and approval. We did update the work plan based on discussion from the December 2025 meeting. Notable changes from the last meeting. On this first initiative, we added consumer law to the assessment opportunities. I just wanted to mention, George, you did note some interest in Social Security law. If it's okay, we left it off for now, for a couple reasons. One, we already had 3 to consider. And then second, it's already an approved area through one of our accredited organizations.
Mhm.
So the National Board of Child Advocacy, they do have a Social Security disability law.
Mhm.
And then related to this initiative specifically, Janelle will be sharing some preliminary findings regarding the 3 identified areas later in today's meeting. And then another next change in recurring assignments related to the outreach. We added outreach to promote the certification deadline and extension period, specifically as it relates to the release of results of the October 2025 legal specialist examination. And then moving on to future items. We added revisit the legal specialization rules that were considered in 2022 and 2023. We do hope to return to this in 2027. We added explore tiered fee structure for certain cohorts following an assessment of any impact related to the recently adopted new legal specialist exam fees. We do plan to look at this after the 2027 legal specialist exam, so I think that a date of 2028 has been noted here. And then we added explore splitting the immigration and nationality law exam to better reflect distinction between family-based and then employment-based immigration law. And we hope to start doing this in 2027. Those were the main changes from the last time that it was presented, but does anyone have any questions on any of these? Mia is also here in case there are any questions regarding the regulation ones as well.
Yeah, and if I could add, thank you, Adrian, for sharing that summary. I just wanted to add, we felt like we got some really great feedback from members at the last meeting. Any of the items that have been identified for future work items, I think is really meant to ensure that we can finalize some of the work this year that we think is relatively time sensitive. And namely, I think that's some of the exam related work. Of course, today we're going to talk about the vendor, but there's some discussions we plan to bring later in the year around the design of the exam. And I think most importantly, maybe exam grading as well. And we'd like to make sure that, well, we think it's important to get that done ahead of the 2027 administration. So I think our thinking was really weighing the capacity to get that work done this year, which really needs to be done before the next administration, and not, really giving that just the full attention because of the time sensitive nature of that work. So I just wanted to add that context for members.
That's quite a bit to take on, but I think it's really, good momentum. We're headed in a good direction on those things. And I'm going to call to see if there's a motion to approve the 2026 work plan, unless anyone needs a few minutes to review this. Okay. Would anyone like to make a motion to approve?
I will, Damon.
I second the motion.
Janelle, can we get a roll call?
Alano,
Aye.
Bennett,
Approve.
Jenkins,
Approve.
LaGlory, absent, Record, absent, Surmitis.
Approve.
With 4 ayes and 0 nays, the motion passes.
Thank you, everyone. I appreciate that.
Thank you for all your work on that. The next agenda item is discussion and action on business requirements for delivery of the legal specialist exam and the rubric for assessing the availability of vendors to administer the exam. And this is going to be led by Cody.
Yeah, thank you again. I am going to walk us through a discussion about the materials that were posted, and I'm going to walk us through it, I think, at a level of detail that we may typically not kind of walk through staff reports and other materials because it's a lot of information. So I'm going to speak a lot. I want to say that at the beginning, but please feel free to stop, ask questions. You can ask me to pause throughout. I don't want to get too far along, and it's a lot of information. I want to make sure that your questions or concerns are heard. So let's go to the next slide. I just want to cover some of the background just to set the stage. This is kind of a new approach, I think, to selecting vendors. We just wrapped up the October 2025 legal specialist examination. The contract with the vendor who delivered and proctored that examination ended after that administration. It was really meant for just one administration. We would typically internally work to secure agreement with a vendor, but it has been a recent initiative of the Office of Admissions to kind of formalize our vendor procurement process and to also kind of do our due diligence and request proposals from as many vendors as possible. All of this is meant to just tighten kind of the quality of the vendors, set expectations of vendor performance, and also just kind of wrap our heads around all of the many different requirements that we feel are critical to an administration being a success. And so what we plan to do for the legal specialist exam vendor is to issue a request for proposals to solicit bids from any vendor that's interested in participate or in being the selected vendor to deliver and proctor the exam. We are following in the footsteps of our the State Bar's the Office of Admissions exam administration team and our operations team, who has similarly released a request for a proposal for vendors for the first year law students exam and the California bar exam as well. And that process has worked very well in establishing, again, kind of these baseline requirements and also for staff to get a better sense of what options are out there. So we plan to issue that request for a proposal. The ask of our members today is to approve the list of business requirements that we're proposing, and also to approve a rubric that we intend to use to evaluate the vendor's ability to meet those requirements. And I'll describe those two deliverables in more detail in just a moment. So as a reminder, prior to October 2025, we administered the 2023 and 2021 exam using ExamSoft as a vendor. And ExamSoft uses an approach called record and review. And the way record and review works with ExamSoft is that there is one element of its software called Exam ID, and that uses a photograph of a test taker and the camera on their computer to authenticate their identification as they're logging into the exam. Then there's a second component to the software called Exam Monitor that records all of the video and audio of the session. There's not a live human proctor. This is all done remotely and without an internet connection required. The recordings are saved locally on the user's device, and then they are later reviewed using an artificial intelligence technology to determine whether a potential rule violation has occurred. So this technology was used by many jurisdictions during the pandemic to administer the bar exam. Essentially, what it is doing is assessing whether perhaps someone's looking away from the camera repeatedly, whether they've stood up and left the space, and a number of other potential violations are flagged. After this administration, staff reviews a list of videos that have been flagged by this technology and determines whether or not a rule violation has actually occurred. When we administered this way, there was a small number of test takers who still had to come and test in person at the State Bar's offices, perhaps because they had a testing accommodation that could not be fully satisfied using this approach. The challenges of this approach is that it trades the convenience of the test taker with exam security. So we have found that this approach is easier for test takers. They don't have to connect to a proctor. They do not have to do kind of the 360 room scan that can often take some time if they haven't prepared their space ahead of the exam. There's a number of reasons why this process is kind of less complicated from an administration and a technology standpoint. However, as you can assume, reviewing the recordings after the exam means that issues are only identified, some period after the actual administration of the exam. That could mean item exposure, cheating, and other risks aren't observed and handled in real time. And the other challenge is that approach was really labor intensive. Staff have to review these videos. The technology is not perfect, so we review a lot of videos that ultimately aren't rule violations, and it's just generally a drain on staff's capacity. So we pivoted, and in the 2025 administration, we switched to live remote proctoring using Prometric LLC. And we've used Prometric for live remote proctoring for the first year law students exams. So this was a process that was somewhat familiar to us. For the legal specialist exam, we also offered the opportunity for a test taker to test in person at a Prometric test center if they had a preference to handwrite their exam, if they could not secure internet connectivity, a stable internet connection, or an appropriate exam environment, and also certain testing accommodations required it. What we found was that 79% of test takers ultimately tested remotely. 71% of test takers tested at these test sites that Prometric operates. Some of the challenges we saw there is that our licensed attorneys are sometimes just less familiar with these types of exam softwares. Many of them have been licensed for some time, haven't been in a legal education space in some time, and so adding the extra requirements that come with live remote proctoring, such as the room scan, the constant internet connectivity, and some of the other requirements, did create some kind of challenges for some of the test takers, and they're unique challenges for this certain population of test takers. And then because it was mostly live remote proctoring, there was about 5% of test takers that had technological issues that prevented them from completing the exam that required us to reschedule. And I think it ultimately ended up being about 15 or so individuals that we rescheduled. And in a live remote setting, that does take time to find them a new exam, to reschedule that session, for some to switch them to in person because it's determined that their computer equipment is just not appropriate. It just a number of different challenges for that small population came up. After the 2025 exam, we surveyed test takers, and we found that more test takers reported that they would have preferred to test in a small test center than they would remotely in the future. So that leads us to what we would like to seek proposals on today. So let's go to the next slide. today we are interested in delivery and proctoring of the October 2027 legal special exam using a hybrid model, but a hybrid model that is in person first. And this is a switch that the first year law students exam made several years ago as well. What it means is that there is the default option for test takers is to test in a vendor operated test center. We secure test centers at multiple locations across the state to try to make it convenient. And then we reserve remote testing for a small number of test takers who either who have certain circumstances that require it. So perhaps someone lives in a very rural community and accessing a test center would be hugely difficult. Perhaps they have a certain need or accommodation, maybe private space, or there's just certain individual circumstances that would require it. We would reserve a small number of seats for them. That has worked very well for the first year law students exam. There have been enough seats secured for those administrations, which are about 200 or so test takers. And that has greatly reduced some of the technological issues. Because generally the test center experience works very well. The computer's already provided. There's someone on the ground to help walk them through the software. And then obviously there's in-person proctoring as well, which is great for security. So this is the model we'd like to pursue in October 2027. And so our materials that are provided are really centered around requirements to deliver this kind of approach. Let me pause there before I get into the new materials. Any questions about kind of the prior administrations and why we are pursuing this slightly different approach for the future?
What is there's obviously a cost difference, right, in a greater number of on-site tests. Is that a significant cost difference?
That's a good question, George. Not necessarily. There are some vendors that have a model in which the test is priced per seat and time, and is it really priced per modality? So depending on the proposal, of course, we could find that vendors have the same price for all test takers because of how much time they're going to be needing to test. That would change, or that could be different for other vendors. And for those, I couldn't tell you until we received the proposals.
Are there any questions from any?
Okay, let's move on to the materials then. Excuse me. So the first piece of the materials needed for us to really make the most of a request for proposals is the list of business requirements. We really believe that by giving vendors clearly defined business requirements ahead of time, that we will not only receive proposals that are from the onset better or more detailed and better aligned with our needs. We really think this is a way for staff to ensure that vendors or that there's no miscommunications about what our expectations are. And so part of our materials is like a 12-page list of business requirements. And those requirements, as I mentioned, are going to set expectations for the proposals, but they're also going to allow the State Bar to streamline its contracting process. When we go to develop our agreements with our vendors, many of the requirements have already been articulated, and they're aware of them, and will be less negotiating and changes that are necessary. So it'll be a huge process improvement. So I want to go through the business requirements, and it's a lot to fit on slides, so I'm going to talk through them in detail. And again, feel free to stop me as we go through this if you have any questions or concerns. So we've kind of broken the requirements out into different categories. The first is related to the software itself. And then within the categories, you have kind of a subset of different requirements. And so when it comes to the exam software, there's a number of security and functionality requirements that we've listed. Of course, the platform needs to be secure. And what we mean by secure is that it requires test takers to remain in that platform and not be allowed to access outside resources. Many of the exam vending platforms do kind of a lockdown. You're not allowed to access the internet or other applications. That is a minimum requirement for security. We would like the ability to randomize questions. Being able to randomize multiple choice questions or essay questions is one way to reduce the risk of cheating and item exposure issues. Of course, the software needs to be able to perform reliably under load. What that means for this exam is we need 400 individuals testing across 13 different exams simultaneously, and for the software to perform quickly and not lag, and for there to not be any other technical issues that arise from the number of test takers. At 400, that is a reasonable expectation. When you get into the thousands or tens of thousands, load can be a bigger issue, but we feel this shouldn't be a problem for the vendors that will submit proposals. Now we're getting into some of the kind of user experience stuff. We need an answer field that supports cut, copy, paste, undo, spell check, all of the normal kind of text editing tools. Users really have come to expect that as part of the experience of writing their essays. And the text editor needs to be familiar to a typical computer user. It needs to feel and look like, for an example, Word or Google Docs or Notepad on a computer. It needs to be something that the user will know how to use intuitively. We need candidates to use annotation tools on the essay question text. That means highlighting, strike through, other ways of manipulating the essay question text. Individuals have come to rely on different techniques for how to cut through information. A lot of it starts with tips for taking the bar exam, but we need that functionality to be available. And similarly, we need functionality to be available for the multiple choice questions. We know highlighting the questions is a big one, but also striking out options so that you can narrow down your multiple choice options. Those are tools that many people are very familiar with, and we think will want that in their experience. Providing a virtual notepad for test takers who are testing remotely. Automatically saving a candidate's work so that if there's a technical issue or the candidate accidentally leaves their exam, that their materials are saved. A timer that's displayed at all times for time management. And then just navigation between the questions within each section so that a test taker can skip a question and come back. Some of this might seem a bit obvious, but all of these features kind of make up the baseline expectation. And so we've included all these in the functionality side. When it comes to accessibility, this is a big one because we have test takers who are going to have different needs. We need accessibility features built into the exam software that include being able to adjust the font size, color contrast, keyboard navigation, right? Being able to use hotkeys to navigate if you're unable to use a mouse or a different type of trackpad situation. The software needs to be able to support our screen reader software, which is text on a screen to speech, or the reverse, to be able to receive voice commands to type text for those who have certain needs or accommodations or limitations. And the vendor needs to be able to clearly indicate and demonstrate how the platform will work for those who need these accessibility features. We've described that the software needs to be intuitive. It needs to be familiar, simple, and consistent with a minimal learning curve. That kind of goes back to my comment earlier. The test taker population here is unique. They maybe haven't worked with a lot of exam software. So it needs to be something that someone can really pick up quickly. We need practice exams and tutorials to be available. We have found that the best way to reduce technological problems and issues is to give people an opportunity to take a mock exam or to do a tutorial days, weeks, months before the exam. And so we've required in our requirements both the access to a tutorial and mandatory mock exam for some test takers, which we administered in the last exam. There's a couple of number of compatibility issues. Computer device compatibility is another area where technological issues come about. Keep in mind, this area is mostly important for the smaller group of people that would be testing remotely, because in the test centers, the computers are often provided for the test taker. But the software needs to reliably run on modern laptops using Windows and Mac OS, the two most popular operating systems. The vendor needs to have clearly specified minimum requirements, including the memory that's needed, the free disk space that's needed, screen resolution requirements. These are the types of computer device specifications that help individuals determine whether or not their computer's up to snuff. And we have found that it's common in these softwares for them to include a tool that detects if a device isn't meeting those requirements and to notify the test taker. And so one of the requirements we've included is that feature be part of the software as well. And then on the security and the reliability side, as I mentioned, the platform needs to prevent users from accessing outside resources. We need functional integrity. Essentially, is the software doing what it's supposed to be doing? If you submit a command to navigate to the next screen, does it actually do so, or is it prone to bugs and confusing behavior? And then of course a number of kind of baseline expectations. It needs to be capable of running without failure. It needs to be stable. Again, minimizing shutdowns and bugs. It needs to be predictable, meaning the exam operates the same when one user is using it during the mock exam, as is the case when 400 users are using it during the actual exam. And we've listed a number of examples of how we want the vendor to be able to demonstrate reliability. And so we've said rigorous testing, quality code, demonstrating that they've got recovery systems, perhaps duplicate servers, so that the system never goes down. And they need to be able to demonstrate that they have all that in place to ensure reliability. Let's go to the next slide. So we have a set of requirements specifically for the test centers. Of course, there's kind of an overarching requirement for each of our categories, but the exam needs to be administered. And what we mean by administered in a test center, it needs to be proctored by a person to ensure candidates don't have access to prohibited items physically in the space. And it needs to be administered to candidates in person throughout California. There is up to 6.5 hours of testing, plus a 1-hour break, and perhaps several shorter breaks between sections for candidates with standard time. And then there's a number of different schedules for test takers who have testing accommodations that may require them to test over multiple days. So the vendor needs to be able to reserve seats that can meet those long days and multiple days in a row. The vendor needs to be able to administer the most common testing accommodations, and we've provided in the requirements document a list of those most common accommodations. Extended time, private or semi-private space, the ability to stand and stretch if necessary. There's a list of other examples, but that all needs to be something that can be by default administered in a test center. They need to, at test centers, be able to receive hard copy materials and return them back to the state bar in a secure way that's determined by the state bar. We have built a strong process with Prometric for the first year law students exam that allows us to securely send physical materials to those who are handwriters or those who have physical materials for some other reason or some other accommodation. The vendor needs to be aware that an expectation will be that we're going to have to ship to them these materials, and they need to be managed in a secure way. There needs to be adequate staffing for a number of different areas: proctoring, technical support, and customer service. When we have our vendors take on this role, they are the interface with test takers on a number of issues. Questions about the mock exam, the vendor really needs to have enough staff to adequately support that, and so that they can support the test takers through the process. And then there's a couple of other requirements in there just around deadlines. We need test takers to be able to schedule at different windows based on our own internal process deadlines, and we need to allow test takers to switch modalities or test centers based on testing accommodations and other needs at different times. All that's baked into the requirements so that the timeline for implementation is very clear from the get-go. As I mentioned, we anticipate about 400 test takers, and of them, about 75% would test in person under this model. So we need a vendor that can reserve 300 seats at in-person test centers across California in at least a 2-day window. There needs to be test centers that are positioned in and near the major metropolitan areas in California. And they need to be able to schedule test takers in a way that everyone begins the exam on the same day and to the extent possible at the exact same time. When at the exact same time has been a challenge, a staggered start is okay, so long as nobody begins their session after the first session has ended. Because you can imagine after the first session ends, a test taker can take their break and they could share information about the exam. So if a staggered start is required, so long as everyone begins before the first session ends, the earliest first session ends, that's sufficient. And then we have in there some requirements about the environment, temperature, noise, and kind of other testing environment requirements. On the proctoring side for test centers, proctors need to be professional. They need to meet some requirements the State Bar has identified. In the requirements, we include that proctors must be at least 18 years of age. They must have a high school diploma or a GED equivalent. They need to possess basic knowledge of vocabulary, grammar, and punctuation. That is because they are often not only speaking to applicants, but are often tasked with writing and reporting on what's going on the ground, incident reports and other documentation. So we've listed out kind of baseline expectations. The vendors need to be able to permit certain test takers to have items in the testing room. We have our list of standard permitted items for all test takers. That needs to be allowed. And then for those with testing accommodations, they need to be allowed to bring certain items in the room as well. Perhaps it's medicine or equipment for diabetes, food and drink. For lactating mothers, it can mean, breast pumps and other equipment. All of that needs to be allowed in the test room. We cannot prevent test takers from being able to access those materials. And then there's some specific legal specialist exam requirements in this list. One of the most notable is that for our exams, there are 4 tests in which code books are allowed as a reference material. So the proctors need to be able to differentiate between those who are testing in one subject area and are not allowed reference materials, and those who are testing in one of those 4 areas who are allowed testing materials, and they need to make sure that they are providing those opportunities for those test takers in those 4 subject areas. Let me get through this next slide, which is remote, and then I'll pause again before I get into some of the more maybe kind of operational side of things. So for the small group, the 25% of test takers that we imagine testing remotely with live remote proctoring, we need a vendor that can administer the exam reliably and securely. For administering remote exams, that means via live video and audio feed. Again, they need to be able to administer the length of this long exam over the 2-day window. They need to be able to support the expected volume. So if we're talking about 25% of 400, we're looking at about 100 test takers, and a smaller number of those testing with accommodations. A lot of the requirements are the same here, so I'll try to quickly go over them, but the most common testing accommodations need to be administered remotely. The schedule, the calendar of implementation needs to meet our deadlines, as I mentioned, for the test centers. Again, the proctoring needs to be meet our standards. There are a couple of requirements on the proctoring side that are unique to remote testing, so I'll just spotlight those for a moment. One, remote proctoring tends to rely on a pool of proctors who are administering multiple individuals' exams all at once. And what we have found is that this model often has proctors maybe proctoring a portion of the exam, and then another proctor steps in to replace them, and then that person proctors the rest of the exam. What we have found is that some of the platforms, that switch is very visible to the test taker. They might see in a chat box that their proctor is changing, or there could be some other way that the user is aware of that change, and that can be distracting or concerning to the test taker. So our requirements include that the frequency of proctor changes needs to be minimized, and they have to be able to change proctors in a way that minimizes interruptions and does not notify the test taker during the exam. This is all meant to kind of create unnecessary distractions. In the remote testing space, we feel strongly that one of the benefits of remote proctoring is the ability to be able to do a 360 scan of the testing environment. So we have included that as a requirement for remote test taking. The proctors need to be able to minimize other interruptions. So we have found that proctors in a remote environment, because they have limited visibility after they do the 360 room scan, they may pause from time to time and ask a candidate to clarify something. Maybe there's an item on their desk that seems concerning, and so the proctor will ask for confirmation that they're not using some resource. We again have indicated that the proctors need to be able to minimize interruptions and should intervene only when necessary. We have a recording of all of the sessions. So even if a proctor sees something that is concerning to them, they can document that in real time, and we are able to review that video and indicate whether a rule violation has occurred. So we really want to try to balance security with the user experience, and that's kind of where this requirement comes from. And yeah, let me pause there and ask if there's any questions about the first group of requirements. Okay, I'll keep going. All right. Moving on to communication and support. These next few categories are shorter, so I think we'll get through these quickly, and then we'll get to the next section. The vendor's communication with the state bar and also the candidates is absolutely crucial to the success of the exam. And so we want to set that expectation up front. We will require the vendor to have regular status meetings with the state bar from the time the exam is executed or the contract is executed. We will require regularly cadenced meetings with the implementation team at the vendor to make sure that all questions and issues are being addressed timely. We will require that subject matter experts are in these meetings. So if there is a vendor expert on software, like a programmer perhaps, they need to be in the room when there's discussions about software. If there is somebody on staff who is their accessibility and testing accommodation expert, they need to be in the room for those discussions. We want to hear directly from the people who are most informed when we're having difficult conversations. So that's built right into the requirements. We are going to require weekly written status reports. The status reports need to include progress on deliverables, including the launch of the mock exam, where we're at with candidate scheduling, seat availability, so that we can monitor where we have seats for test takers and whether or not we're finding that certain communities are maybe short on seats or facing different challenges scheduling their exams. We will require that they report and identify risks or challenges to the state bar no later than 24 hours after identifying such risks. This is meant to set a baseline sense of urgency about resolving problems before we're too far downstream. And then we will require that the vendor have staff available for live communication on the day of the exam. We have learned through several different exams that having what has been called flight deck, or this term's not accurate, but what's been called a war room at times, having everyone in the room ready to address real-time issues is by far the best way to resolve them. And so that is a requirement of the vendor that they have those staff available on the day of the exam. On the candidate side, the vendors really take on a huge responsibility communicating directly to the candidates. So the vendors are required to communicate with the instructions on how to schedule the exam and the deadlines, communications that confirm that an appointment actually has been finalized and completed, verification that any required mock exams have been completed so that test takers know that they've completed their requirements that we will place on them. And any other information that we deem kind of necessary for the user to know or to hear from the vendor directly on, we will be requiring that of the vendor. And then for remote test takers, there needs to be a live chat option for candidates on top of any video and audio discussion opportunities, but there needs to be a live chat option so that during test day, the applicant has plenty of opportunities to communicate with their proctor if there's any issues that arise. We've included reporting requirements as well for the state bar to really hold vendors accountable, and also for us to analyze the success of our exams. There's a lot of reporting that needs to occur and a lot of data that we need. So we need access to the post-exam videos and reports, and we need it very quickly. So we have indicated that any of these videos, reports, and information needs to be provided to the state bar no later than 3 days after the administration. We need reporting on the mock exam. If anyone is required to complete a mock exam before the exam, we need to know whether or not individuals actually successfully completed that exam so that we can communicate with them and ensure that they're doing it. That's so that the test taker is familiar with the software and has ensured their computer works well. We did a lot of direct communication for the October 2025 exam on this front. So we need to be able to get that information so we can identify folks who maybe need some more outreach. Answer files is another area. You'd be surprised, but the format of some software's answer files can be challenging. So even though it's a bunch of multiple choice responses and 8 essays, we sometimes receive answer files in a format that's not usable on a typical software. Or for the essays, for example, we might receive answer files where we have 8 essays for each test taker times 400 test takers, so 2,400 essays merged into a single file that's really difficult for us to parse through. And so we have requirements in this document that says we need a single file with all of the multiple choice questions for each applicant organized in a way that's usable. And then we need the ability to receive the written responses as a single PDF for each response for each test taker. That's going to facilitate our grading needs. And then the last category, I'll just breeze over that, but we just included a number of other requirements that is meant to make the reporting consistent, quick, and articulate some of the minimum requirements that should be included in certain types of reports. Okay, just a few more requirements. On the implementation and risk management side, again, providing a mock exam is absolutely critical. That's how we ensure that test takers are reducing the risk of tech or user complications. They need to be able to provide exam day technical support to tech candidates using trained technicians with a clear protocol for escalation so that users can quickly get to the right person who can help with their problem. It is required that the vendors disclose any prior technical issues and root cause analysis and corrective actions that might have occurred in any prior exam that they've administered. We have asked for them to demonstrate successful use in similar exams. For the legal specialist exam, that could include other similar specialization exams for other jurisdictions. It could also just mean an unrelated exam that's of similar length, number of questions, and format of the exam, because those are the kinds of configuration challenges that could lead to unexpected implementation challenges. There needs to be a clear implementation timeline, and the vendor must describe that implementation timeline and provide it to us ahead of time. And the implementation timeline needs to include enough time to allow the state bar to test the platform and to make any necessary changes well in advance of the exam itself. And so we will also include in the requirements and also any agreement that we execute that at the state bar's request, the vendor needs to provide documentation related to risk management issues. So it could be financial documentation to demonstrate their financial viability. It could be disclosure of vendors that or subcontractors that could pose risks that we're unaware of, forensic analysis into technical issues, just a number of different pieces of information that we'll have the right to request of a vendor. And that's kind of also related to our security and compliance requirements. Beyond just disclosure, we are going to require that the exam content and data is encrypted. There needs to be a lockdown environment for the test taker that provides security, so no apps, video applications, or other software can be running. All candidate information needs to be held confidential. Vendors must retain candidate information and other sensitive data for an extended duration that's specified by the state bar that allows us to perform review and audits later after the exam. And as far as candidate PII, personal identifiable information, all of that needs to be destroyed at the direction of the state bar. So we'll have limitations on retention and other policies related to that. We also list in our requirements a number of basic compliance standards. There are compliance standards related to data security and reporting. And so we've listed those there. I won't get into the specifics because they're a bit niche, but those are kind of industry-wide compliance requirements. We will also require compliance with basic data security, data privacy, and accessibility standards. And again, we've listed the most common kind of industry-wide practices. And they need to demonstrate that the vendors undergo third-party audits every 12 months to ensure that they meet these compliance requirements. And as has been kind of discussed more often these days, artificial intelligence use needs to be disclosed, and any use of AI can only occur with the written permission of the state bar. All right, and this is the last of the requirement slide, deliverables. So the vendors tasked with obviously delivering the platform, they need to allow up to 20 individuals to test the software in real exam environment setting with a proctor, things like that, or in person. I'm going to skip some of the things we've already discussed. There's a clear scheduling deadline that's based on our application and processing requirements that's articulated in the deliverables as well. When it comes to the actual proposals, it is required that the proposals are transparent. They need to include a per candidate fee structure. We need to understand whether there's any additional technician or staffing costs. There are some vendors who may send or may have specialized technical support users that we can select to have available on the exam date at an additional cost. That needs to be communicated to us. And then unique to this exam, it needs to be clear how the exam is to be, how the fee structure works in a situation like the legal specialist exam, where we call it a single exam, but we are actually administering 13 different exams simultaneously. So the fee structure needs to really be clear about what that means, whether it's if a per exam fee really means per exam times 13. These are some of the nuances that I think could be missed early on. And so we want the vendor to be upfront, very clear about what this cost will look like for our unique structure. And then, yeah, incident reports, videos, other reporting requirements are part of the deliverables as well. So that's the biggest chunk of the materials. Let me stop again because that was a lot. Any thoughts, questions, concerns about the requirements for the vendors?
Are these significantly new from prior requirements or the criteria?
Not really, George. What is new is that they are written down, that they are being reviewed by different stakeholders, and that they will be given to the vendors at the time that they're drafting their proposals. What has historically been the case is that we meet with a vendor, and through a number of discussions, staff articulate all these requirements. But that risks misunderstanding. It risks inconsistent communication of the requirements, things like that. So I would say for the most part, a lot of this reflects current practice, but has synthesized it.
So it's more formalized in detail.
Yes.
Mm-hmm. Okay, that's great.
Okay. Let me go to my last few slides here then. So this is really a two-piece discussion. So when we release the request for proposals, the business requirements will be provided to the vendors at that time. The vendors will then submit proposals. What will then happen is that we will evaluate the proposals that we receive. And let's go to the next slide. Let's, sorry, one more slide. Okay, you know,
Looks like
see.
Adrian froze.
Yeah, that's good. I've got the slides up on my own computer, so let me switch over to mine. Okay. Okay, so we have, as I mentioned, been following a more formalized procurement process, and we intend to follow the same process that's being used for the bar exam and the first year law students exam vendors. And so what procurement has provided us is a standard process that we've used across the state bar. And what will happen is vendors will submit their proposals. The proposals are evaluated on under 4 categories. Category A is just, did they meet the submission requirements? So we have a standard set of submission requirements, so financial documents, written proposal, and some other maybe like proof of good standing. I can't recall exactly the full list, but procurement has a list of submission requirements that every vendor must submit. Category A is, did they meet that requirement? You get 10 points for doing so. Category B is, did they meet the contracting requirements? Similarly, procurement has a standard set of contracting requirements that all vendors have to meet. You get 10 points. I'm going to skip C for a second, and I'm going to say category D is just total cost. We will evaluate on a scale of 0 to 30 points, how costly is each proposal. Category C, this is where our discussion today fits in. Category C is called our vendor suitability category. And we can appoint up to 50 points to a proposal based on vendor suitability. And vendor suitability really is, in this instance, to what extent has the vendor demonstrated that they can meet these business requirements? And so a vendor may be able to meet all of them. In that case, they may receive 50 points. A vendor might be able to meet most, but not all. But yet they meet the most important and critical requirements. And, a reviewer might give that individual 40 points. So we will have staff, and if approved today, our chair and vice chair review the proposals and give them scores based on the structure. And the vendor with the highest overall score will be the one that's eligible to enter into a contract with the state bar. Because category C is the vendor suitability rubric, that's the area where we have the ability to modify it if that's deemed appropriate. So I want to get into the rubric here in just a second, but let me actually take one step back. There is also, I'm sorry, I skipped this talking points. Let me take a step back. There is also a part of the vendor proposal process in which we'll be evaluating whether the proposal exceeds, meets, or falls below expectations. So there's a couple of different kind of assessment criteria, measurements that will be part of this process. So before I get to the rubric, let me define these definitions. I apologize. So a vendor that is, when their proposal is reviewed, when that proposal is assessed, if it is assessed to have, quote, not addressed the requirements, this is a vendor's proposal that really fails to meet the criterion in a meaningful way. It might not satisfy the like overarching administration requirements, right? Something critical such as does the platform securely administer an exam that prevents individuals from accessing outside resources? Failure to deliver that high level requirement, that could mean that it really meaningfully fails to meet the requirements. It could be that a proposal is very vague and doesn't provide enough detail to fully assess it. That would fall into the not addressed category. And then from there, of course, there's below expectations, meets expectations, and exceeds expectations. Exceeds expectations would really be a scenario in which a proposal really stands out as particularly impressive. So it's met all of the requirements that we've indicated. It's exceptionally well written and detailed as far as how they'll meet those requirements. They've perhaps provided some data or evidence to support it in a way that others didn't. Or perhaps the platform just provides a user experience that we hadn't anticipated, that when the proposal's assessed really stands out as being exceptionally easy to use, or just providing some new functionality that hadn't been considered. So now let me get to that rubric. I apologize for that. Okay, so now this is where it comes in. So we have our 50-point scale of vendor suitability. We have our categories, our definitions. Does it meet expectations, exceed expectations? Does it fall below expectations? Or does the proposal not address the requirements at all? And then within those definitions is a range of points. So a user will use this rubric, or one of our reviewers will use this rubric, and they will look at, let's say, candidate experience, and they will determine, okay, I think out of 15 points, the candidate experience really deserves to be a 10. And that meets expectations. I'm going to give it 10 points. And of course, go through these other categories. What we've built in as a safeguard is that under this policy, if a proposal gets 2 or more below expectations, it cannot be considered for a contract with the State Bar. So we're really looking for only those that meet expectations or exceed expectations almost entirely across the board if possible. So each one of these categories on the left-hand side is provided a points scale. We've identified 2 that we believe are the highest priority. That is the user experience and then the implementation and risk management. So those receive the highest scores. And then we have our standard priority categories, some of the reporting, file management, past performance, and other categories. The documents that are attached to the agenda have some more specific examples, but I just want to breeze through these quickly. On the candidate user experience, that would include all of the accessibility functionality, the requirement that it is a platform that's familiar and easy to learn. That would include the performance of the platform during testing or during a live exam session. The text editor that I described briefly, how functional that is. All of these requirements that fit under user experience would go into a reviewer's assessment of this category. I will say the categories are still relatively subjective. So in that big list of requirements, business requirements, it's not like we've said this business requirement only is related to candidate experience and this business requirement is only related to implementation and risk. Will be up to the reviewers to really think about the business requirements and assess how they are meeting these categories, candidate experience being one of them. Implementation and risk worth 15 points. Some of the requirements we talked about, the timeline and risk mitigation plans, the system requirements, the mock exam environment that's meant to reduce technological issues, and then some of the stability and consistency of the platform that we described earlier. The grading and file management's a lot to do with the answer files, the ability to report and deliver to the State Bar materials that are easy to work with for our grading and answer file management. Along with some other features, the ability to anonymize answers and kind of just the basic operational needs for our grading purposes. Capacity and support is it could include a number of things. Some of the examples, the ability to meet the State Bar's policies and procedures. So we've given in our requirements a timeline that meets our needs. How closely aligned with that timeline can this vendor's or how closely aligned with these requirements is the proposal. Financial viability I discussed. The support staff that's provided and how the level of expertise that those individuals carry in their respective areas, support for the candidates, all of that can fit under this category. Again, it's going to be kind of a holistic assessment. So reviewers will consider all the information they've seen in the proposal and consider which fit under capacity and support and score that category accordingly. Security and compliance, we shall we should be receiving some of the compliance attestations and demonstration of compliance with those standards that I mentioned earlier. So there'll be some materials that we can assess when reviewing proposals. The ability of the platform to lock down the computer environment for remote test takers, another important piece of this. I think we'll generally, I imagine vendors will generally be wanting to be very, they'll want to be promoting their security and compliance functionality and features. So we should hopefully be getting a lot of this information in the proposals themselves, in the narratives of the proposals. And past performance, of course, is how they've communicated their ability to administer a similar exam in the past. So that is the second piece. Any questions about kind of the rubric and how the rubric will be used to assess proposals and give them a point score? Okay. Well, then with that, what we are seeking today is for the members to approve the business requirements, approve the rubric with the point structure that I shared in this table. That's part of the attachments. And then also to approve our next steps. What we imagine being the next steps is that the State Bar issues the request for a proposal, that staff that are part of the legal specialist program team, along with our chair and vice chair, be assigned reviewers for the proposals, score the proposals using the rubric, and then based on those scores, the one that receives the highest score will be selected as the vendor to deliver and proctor the October 2027 exam.
And would someone like to begin with a motion with regard to the proposed resolution?
I move to approve the rubric.
And do we have a second?
I can second it.
No, can you call a roll call?
Alano,
Aye.
Bennett,
Approve.
sorry. I can't see the roll call. Jenkins,
Approve.
McGlory, absent, Record, absent, Sermitis,
Approve.
with 4 ayes and 0 nays, the motion passes.
Thank you. I know that was a long one and a dense one. I really appreciate it, the opportunity to share that information.
Thank you, Cody. That was a very informative and good presentation. Our next item is discussion on identifying possible new legal specialty areas. And this is going to be led by Janelle.
Sorry. Too many screens going on at once. Sorry. So I'm going to go ahead and discuss the discussion and action if appropriate on identifying a possible new legal specialty area to explore. So this review compares personal injury, healthcare, and consumer law against the State Bar's assessment standards for potential specialty certification. And the analysis considered, can you go back one more, Cody? Just thank you. Analysis considers several factors, including public need, access to justice, the practice demands, and the practitioner's practitioner support and program feasibility. Next slide, please. So we'll go ahead and look at the background. So at the 2026 CBLS work plan includes accessing a possible new legal specialty areas where there may be a justice gap or where other CBLS criteria and board directives are met. The CBLS updated the process for identifying a new specialty area to include early board engagement and feedback for undertaking a larger effort. And then the CBLS has updated the assessment standards for new specialty areas to place greater focus on access to justice issues and response to the board direction. Next slide. So at the December 2025 meeting, staff walked you through the current process for recommending a new legal specialty area. So with this diagram, you will see that we are currently at the proposal stage. If CBLS is ready, we can go ahead and move forward on a motion on the area we would like to move forward on with exploring with all the information that's going to take these next few slides. Slide. So the purpose of today's discussion is intended to share our preliminary research. We will provide a summary for the public available information we collected so far. Some standards will require additional outreach to other jurisdictions, attorney organizations, and practitioners. We will welcome CBLS feedback on where the additional engagement should be focused. We'll also seek CBLS guidance on which opportunities should be researched further. And then that input will help determine what additional information is needed to support a future recommendation. So first we look at the working definitions of what personal injury law is. Texas focus on litigation involving physical or mental trauma and a broad range of tort-based claims, as well as Arizona. Their legal specialization, they similarly include injury and wrongful death matters, along with related insurance and coverage disputes. Together, these definitions help frame the general scope for personal injury as a potential specialty area. So, as we see here, healthcare. This is jurisdictions, they frame healthcare as a regulatory and operational practice area. Florida focuses on laws and regulations affecting providers, payers, and the delivery of healthcare services. Louisiana similarly covers legal issues involving providers, patients, payers, vendors, regulars, and other involved healthcare delivery and financing. But both definitions both definitions exclude personal injury and medical malpractice, which helps distinguish that healthcare has related practice areas. Consumer law. So these sources suggested consumer law can include both individual consumer claims and business compliance issues. Texas defines the area broadly to include disputes involving warranties, sales, leases, landlord-tenant matters, insurance, credit, and collections. And it also includes work under consumer protection and commercial statutes at both the state and the federal levels. In California, the related section focuses, they're highlighting antitrust, unfair competition, and trade regulation issues under both state and federal laws. Next slide. So we went ahead, as I stated, we took the assessment standards from the application, and we went ahead and tried to answer some of the questions that were provided. So this slide provides information relevant to the assessment standards on whether other entities represent attorneys in the proposed specialty area, or they offer a qualifying certification program under Rule 3.903. So the assessment standards are whether other entities represent attorneys in the proposed specialty area. Personal injury law identify the recognition of this area through certain local bar associations, including Orange County and Beverly Hills. as well as any adjacent specialty sections within the American Bar Association, the tort trial, and the insurance practice sections, which reports a network of more than 10,000 members focused on tort, trial, and insurance practice. Then we have the healthcare law. The information identifies recognition of this area through the American Bar Association Health Law section, the California Lawyers Association Health Law Committee, multiple law and state bar associations, as well as the American Health Law Association, which they report approximately 12,000 members. For this assessment, for consumer law, this recognition of this area through committees within the American Bar Association as well, the California Lawyers Association, Antitrust and Consumer Protection Section, multiple bar associations and other jurisdictions, the National Association of Consumer Advocates, which reports more than 1,500 attorneys, and the Consumer Attorneys Association of Los Angeles, which reports more than 4,000. On the next assessment standards, may be eligible to become an approved certification entity under the Title 3, Division 2, Chapter 2, Rule 3.903 of the Rules of the State Bar of California. Personal injury law identifies certification programs in this area through their Texas Board of Legal Specialization, which offers personal injury trial law certification, and the Arizona Board of Legal Specialization offers personal injury law, as stated. And then we have healthcare law, which the Florida Board of Legal Specialization and Education, as well as the Louisiana Bar Board of Legal Specialization, which both have healthcare law certifications. And so we also have self-reporting attorneys for the state bar. So consumer law. The information identifies recognition of this area through committees within the American Bar Association, the California Lawyers Association, and multiple bar associations in other jurisdictions. There's 1,500 attorneys as for the National Association of Consumer Advocates. And then we have the Consumer Attorneys Association of the Los Angeles, and they have members. Next slide, please. So here we looked at the consumer challenges and the extent to which each proposed specialty area may meet the standards demonstrated as perceived need. For consumer challenges, the application asks that the consumers have difficulties identifying competent counsel in the specialty area. And in personal injury law, consumers may have difficulty identifying competent counsel, as attorney selection is often influenced by marketing rather than objective indicators of expertise. And then for healthcare and consumer law, we noticed that additional research is going to be needed to fully assess the standard. Another question asked if the consumer seeks counsel in the specialty area are particularly vulnerable or at risk. For the personal injury law, the data suggests that low-income households may be more vulnerable as they experience personal injury issues at higher rates than higher income households. For the healthcare, and that suggests that consumers may particularly be vulnerable as these issues are common among the lowest income households and especially affect seniors, persons with disabilities, and survivors of domestic violence. For consumer law, the data suggests that consumers may be particularly vulnerable as these issues affect nearly half the lowest income households and especially common among seniors in them as well. So another question for, the primary consumer is more likely to be an individual rather than an organization of business. We found that both personal injury law and consumer law, the primary consumer appears to be an individual. The California courts identify individuals as the primary consumer, in personal injury law, and LexisNexis similarly identifies individuals as a primary consumer in consumer law. So for the healthcare law, the primary consumers appear to be organizations, including hospitals, physicians, groups, as indicated by the American Health Law Association. Next slide, please.
Yeah, and Janelle, before I switch to that next slide, I want to underline this one standard. Members may recall when we updated the assessment standards in December of 2025, one of the things that we really took away from the access or the justice gap study was the need to invest in this people law segment. These practitioners that are mostly supporting individual clients as opposed to businesses and other large organizations. So as part of CBLS's working to meet the directive from the board that its work in specialty areas address access to justice issues, this was one of the new assessments requirements that we added, because the thought being that certifying specialists that work in these people law segments is one small way for us to support growth, but perhaps maybe just awareness and visibility of those practitioners. So I just want to point this out as a new criteria really rooted in the access to justice issue area. Okay.
So as we move to the access to justice slide, this slide presents information related to access to justice and the extent to which each proposed specialty area may meet the standards demonstrating perceived need. So the assessment standard states that the specialty area is identified in the State Bar's Justice Gap Study or other research as one in which the legal services are underutilized or unavailable. For the personal injury law, the California Justice Gap Study suggests that this area may be less underutilized than others, as Californians are more likely to seek legal help, as 50% and they seek 50% seeks legal help, and about 34 receive that for each issue for legal problems. And then for the healthcare law, we have it also, the California Justice Study Gap suggests this area may be underutilized as well as about 11% seek help and only 9% actually receive legal help for this matter. Then we have the consumer law. The California Justice Gap Study suggests that this area may be underutilized as well, with 10% seeking legal help and only 8% receiving it. The assessment standard states that this certification, the next one, may improve access to legal services, positively influence consumer perceptions of the legal system, and increase the consumer confidence that legal help can assist in resolving their problem. So for the personal injury law, certification may improve access to legal services and increase the consumer confidence, particularly because consumers often rely on marketing when selecting an attorney. And then we have healthcare law, certification may improve access to legal services by helping identify attorneys who represent individuals in an area where the primary consumers are often businesses or organizations. And then we have consumer law. Additional research and engagement are going to be needed to assess whether this certification may improve the access to legal services, consumer perceptions of the legal system, or confidence in accessing help. Slide, please. So the practice considerations and potential value, we went ahead and looked at this. And the personal injury law, competent performances appears to require significant knowledge and experience due to the range of subject matters involved in the need for litigation experience. And then we have for healthcare law, competent performance appears to require significant knowledge and experience because it also involves many subject areas within a highly regulated industry. For consumer law, a competent performance appears to require significant and substantial knowledge as well as experience because it involves many subject areas and numerous state and federal consumer protection laws. And then we have for personal injury and consumer law, this does not appear to be a barrier as practitioners commonly work in large, small firms according to independent market research. And for the healthcare law, it may be more difficult for small practitioners as attorneys in this area to tend to work in-house or at large firms according to American Health Law Association. And we look at the laws rapidly evolving rapidly as well as additional value. We stated that additional research and engagement are needed to evaluate these two assessments questions. So the law is rapidly evolving and whether certification would provide added value. So substance. So these standards ask whether the area requires specialized knowledge, experience, and distinct tasks. They also ask whether the activities together for a recognizable law of area. For the personal law injury, other jurisdictions point to reoccurring issues such as standards of care, insurance, government claims, trauma-related litigation, and tort claims. For healthcare law, other jurisdictions identify specialized areas such as HIPAA, False Claims Act matters, reporting requirements, public program rules, provider relationships, and healthcare delivery. And then for consumer law, other jurisdictions identified debt collection, consumer protection laws, and enforcement by consumer protection agencies. Overall, these examples suggest that each area may involve a distinct body of law and specialized practice requirements. Next slide.
Janelle, before we move on to the next slide, I want to spotlight one piece of this slide. The last row, consideration of other areas of law that are related or overlapping. I think traditionally, well, not traditionally, I think that means two things. That is one way of determining kind of the scope of a proposed specialty area and whether or not it should include some areas that overlap greatly with it. But one other way of thinking about that we've included here that I think is important is whether or not there are overlapping areas of law for which there is already some specialization program out there. And so we wanted to spotlight that here. When it comes to personal injury law, there is some overlap in legal areas related to civil trial advocacy and medical malpractice. Those are two areas that we already accredit specialization entities to provide specialization programs. Similarly, in the healthcare law space, there is some overlap with the content that's included in elder law and Social Security disability law areas, as well as particularly in the areas of HIPAA and patient privacy rights, some overlap with some of the privacy law specialty area topics that will be pending approval and implemented in the near future. And on the consumer law side, similarly, some data-related topics will be covered by privacy law. And there's also the consumer bankruptcy and creditors' rights areas that we already accredit specialization entities. So I just want to offer that to members. I feel like there's a risk that we forget about some of the programs that we've accredited that are our own legal specialty areas, but that are out there. And I think that may play a role in determining whether practitioners already have opportunities to be specialized in these different areas. And that might play a part in determining whether we should pursue a new area. So I just wanted to underline that. I think that's an important distinction, a way of looking at this assessment that we've included in this slide.
As we move to the interest and support, it asks that evidence that current practitioners support creating certification in the specialty area, an opposition or concern among the practitioners regarding certification in the specialty area. And we identified that additional research and engagement required to further explore this. Program viability looks at whether there is a sufficient practitioner base to support certification. Personal injury law appears to have the broadest practitioner base, and healthcare law and consumer have a smaller self-reporting practice groups, but show support through related membership organizations. And then the number of attorneys likely to seek certification is currently unknown. I think that the new fees as well as the privacy law implementation may provide a little bit more helpful insight into future demand of a legal specialist. And then more information will be needed to assess, the standard for that. Based on the estimated expenses from the November 2025 fee revisions, approximately 35 applicants may be needed to take the exam. However, 3 of the 13 exams had more than 24 test takers. So it assumes expenses are spread evenly across all exams. Go ahead, Cody.
They're good.
So then we have CLE, the offering appear robust across all 3 areas. And then we have personal injury law and consumer law. Each have identified programs that exceed the 12-hour benchmark for continuing legal education. And then we have consumer law also appears to have sufficient CLE support through existing provider programs. And then overall, the standard appears to have met for each area.
Yeah, and what I was going to add is, looking back over our privacy law work, there is a robust population of privacy law attorneys in California. And I think the proposals that were considered at that time really leaned on that large population to assume that there would be like a very large interest in this program. And we're certainly hoping for that to be the case. I really want to point out here, I think it's really important that estimates like those aren't entirely, they're not rooted in a real model. So we were really hesitant to try to estimate how many attorneys are likely to seek certification. Prior to the privacy law area, I think it had been many years since we had started a new specialty area. And so I think our answer really is we do not know. And the implementation of this privacy law is going to be really telling. If the level of interest we see is similar to what was estimated at that time, then I think we can say using the population of attorneys in this area was a useful way of creating this estimate, and it was relatively accurate, and that is good. But we really didn't want to overpromise here, and so we that's why we didn't provide that estimate. On the flip side, and Janelle said this, but I really want to underline this too. For us to meet the expenses of administering a new exam, we need 35 people to take the exam every year. And it would be completely reasonable to think, okay, well, it doesn't really matter then what our estimate of the number of attorneys to seek this is, because getting 35 people to take an exam every 2 years shouldn't be a problem. Janelle said it, but I just want to reframe it. 10 out of the 13 exams in 2025 didn't have 35 people sit for it. It had less. So it feels very attainable. And obviously our work plan has communication strategies and other things we want to implement to increase the participation of program. But I feel we have a responsibility to say that even hitting this 35 might be a challenge. And that will then mean costs that exceed revenue. So anyways, it's really important for you all to be aware of that, and I just wanted to flesh that out a little bit.
So this discussion, we're seeking feedback on whether consumers have difficulty identifying competent counsel in specialty areas. We also welcome input on whether certification can improve access to legal services or consumer confidence. And we're also, another area of discussion is whether the law in the specialty area is evolving rapidly. And then we finally seek feedback on any additional value certification could provide to the public, legal profession, or the justice system. Has her hand raised.
Go ahead, Pamela.
Okay, my volume, I can barely hear you. I heard her clear earlier, so I wasn't sure. And I will go ahead and lower my hand. But my question goes back to when she was listing the definitions. And I wanted to find out, I know you listed various states, Texas, Arizona, Florida, Louisiana. And I want to know if you were just using the definitions, or you actually, if we're considering following how they've actually practiced the fields in their states.
That I think I understand the question, Pamela. Let me give you my answer, and you tell me if I didn't get to the heart of your question. For the purposes of this initial research, we needed to have some scope to work within, and so we use the definitions that these jurisdictions use for these subject or for these specialty areas to conduct this research. So that gave us kind of a parameter to work within. We have no obligation to create specialty areas in privacy law, health law, and consumer law that are the same scope as those jurisdictions. And if we pursue these areas further, it'll be the work of the future consulting group to help recommend what these specialty areas should look like. So I'll give you a good example. The health law specialty in other jurisdictions is really centered around the type of work that one would likely do if they are representing a large organization like a hospital system. So that's the working definition that we had available to us because that's what exists. But it could be that CBLS says we want to create a specialty area in health law for that small population of individuals who represent payers and patients, and that would require a consulting group to kind of set that scope and definition. So these were really just a starting point for us to keep our work in some organized place, organized scope, but it should not be binding in any way. Was that the question with what the definitions were, or was there something else that you wanted to get at?
No, I was just wondering, the definitions were there, but I was in terms of practice. What rule of law are you going to be following? California's, and actually how California practices versus how the other states actually practice and what that looks like in real time.
I mean, I guess if this continues, the consulting group will create the for example, the standards, the test and the testing subjects, and those will all be scoped to like California law and elements of California practice. So that will come in, but that will happen much later in the process once we get to the consulting group phase. It can be part of today's discussion as far as helping us direct our attention to maybe groups that we could speak to, or adding some more nuance to the research that we're going to bring forward. So I guess we'd take some input on that as well, right, at this phase of the process too. But before we move on, let me add this. The reason we wanted to have this slide here, just pause for a second. As you noted, there are areas in this very preliminary research where we said, we don't know the answer. We're going to need to do some more research. And what that really means to us is go speak to the jurisdictions, speak to some of these local and California groups that represent these attorneys, and speak to actual practitioners to help us answer some of these questions. But before we do that, we have here in this room attorneys and those who are just maybe familiar with these spaces. And so if you had feedback that could help us fill in some of these gaps, we'd love to receive it now. If not, we'll go on to the next part of the discussion, but I just wanted to make our ask a little more clear here. Okay, Janelle, take it away.
All right, so we move into the next slide, please, Cody. For the discussion, we are asking guidance from the CBLS to and inform us of next steps. So this slide is intended to guide discussion on whether any of the opportunities reviewed should move forward for additional exploration. The considerations reflect where the preliminary research appears to point, which also showing that no single area is favored across every factor. So for healthcare law and consumer law are supported by attorney groups, group interests, and underutilized legal help data. And personal injury law is supported by consumer population and practitioner makeup. And the healthcare law also appears in existing programs in other jurisdictions. So additional information may still be needed before CBLS is in a position to make a further recommendation. But we ask to also keep in consideration that privacy laws intended as an additional consideration because implementation effort and the resource demand would need to be weighed against other CBLS priorities. We also have to look at the level of effort into implementing the new privacy law specialty area. We have to recruit exam developers, pre-test questions. We have technological and administrative updates for applications. And then we have to understand the level of effort to manage a possible consulting group in the light of another CBLS priorities. We have to recruit members. We have to appoint a chair, hold public meetings, identify subject matter experts to present at meetings, and then develop a new set of standards and exam specifications, as we did for the specialty area of privacy law, which we want to hopefully get off the ground soon. Are there any questions, comments, and concerns regarding this?
Yeah, I would love to hear from members if there's any one of these three that particularly stands out. The kind of engagement we're talking about as far as next steps, I think is going to be it's going to require a lot of individual outreach to groups and individuals. And so if there's one or more, but less than three options that are interesting, that helps us focus our efforts. Of course, it's a decision for the members here to make. If all three still are appealing, then we'll do that work. But if there's something about what we've presented that really helps narrow things down, we'd love to hear it.
Well, it seemed to me that healthcare law tended to lean more towards doctors and providers in that area. Um, um, and at least from what I saw, maybe carries less urgency right now than the remaining two areas, particularly with our goals and the different factors there. At least that was my take on things. So I feel like the focus should be on consumer law, I think definitely, based upon, what I've seen. And I think that would really help the public, whenever our roles also is to protect the public. And personal injury law, I think that warrants consideration.
I agree with everything you said, George, and I think it's important to just point out how much higher the numbers were for personal injury attorneys, and if revenue is going to be a consideration, we shouldn't lose sight of that also.
If we move forward and research those two options, are there questions that you need answered or information you feel like you need us to bring back from our discussions with these practitioners and groups that would help answer any gaps that you currently have? And maybe not even just as parts of our assessment criteria, maybe you just have questions for these individuals and groups that you'd like us to include in our discussions that we can bring back to.
I think Pamela had a good point, and it might be helpful to know how these specialist areas are working out in other states. If they're having, hopefully they're not having the same issues that we have with some specialties, and that they aren't having people sign up for it. I think it might just be helpful to know that. That's just one thought.
Yeah, no, that's great. And I'm sorry, Pam, if that was the question you were trying to get at, I misunderstood your question then.
No, it
Yeah,
wasn't.
Oh, okay.
It's okay.
Okay.
I
Okay.
misunderstood too. Sorry.
No,
Well,
it's
but
cool.
it's a
I just
good
wanted to
question,
know.
David.
I just wanted to. I know other states. Every state has their way of practicing a law that they institute. So I was just wanting to make sure that California would be our primary consideration. And yes, you may want to look at how Florida may do something, but they're guided in a different way than California's guided. So that was my
Oh, yeah.
my thing with that.
Oh, yeah. Practice requirements and all
Yeah.
that will be centered around California. Consumer law is probably a great area. We have
Mhm.
obviously specific state consumer protection laws. We
Mhm.
have specific state agencies and complaint processes and things like that. So it'll be California specific
Mhm.
for sure.
And the only other thing was when you were covering the piece about the noise and the distractions, if they could clearly say how would you, like if you were sharing how the people may need a different tool, but if there's a specialty where how they controlling the noise in the room, and so that any movement, if someone needs something that's not a distraction to the entire floor, so things like that where the test takers are not distracted from the testing. So
Oh, yeah, going back to the prior item, yeah. Not just reducing distractions in the remote setting, but capturing some of the distractions, possible distractions in an in-person environment. Yeah. Any other thoughts or questions on specialty areas?
I'm most curious about what practitioners in those areas, at least the two I've talked about, think of this. And the level of engagement and what they think it would bring to the public.
Yeah, definitely. And George, that's why there was the two assessments, whether there's opposition or support for this. We didn't even try answering that because we feel like that is really trying to echo the voice of the actual practitioners. So that will definitely be a part of the discussions, whether there's support for this or not.
I wanted to say that I have a vote for healthcare law. I'm trying to summarize it. I'm trying to articulate it and I'm trying to find the best point, but maybe just that the consumers are less likely to be able to seek and find help in that area. And I see the, elder care. I just see it as people at their most vulnerable, unless I'm not really understanding it all yet. But anyway, I have a vote for that.
No, Grace, I think you're understanding it. I think what we saw is kind of what you were just touching on. The Justice Gap study definitely suggests that health related legal issues are a big issue for vulnerable populations. And then what we saw on the flip side was there wasn't a very large group market of practitioners who serve those individual patients. And so that is a something to weigh against one another. That's kind of hard to yeah, we wrestled with that, I guess is what I'm getting at. There's this huge perceived need, but there's maybe not a market to serve it, and we didn't know where to land. That's why we wanted to give you those competing things and have this discussion on that.
And I think it depends on what healthcare law means. I mean, we have, for example, consumer law, it might fall within that. There are practitioners in elder law as well. I think it depends in part on how it's defined and what that encompasses. Grace, what is your understanding of healthcare law, or what are the specifics in that?
I think it's just because I came from my father having cancer and passing last year and being so you know lost in the world of Medicare and all of those issues. So I'm coming from more of a personal place. You mentioned consumer law, and I see like wide variety of subject areas. So I guess that's kind of an open question too, is what would those, like you said, healthcare law could fall under that umbrella possibly. I think these are just ideas that I'm formulating now, like
Yeah.
trying to grasp now, like what would these areas be under consumer law for private attorneys? But I think it's ultimately also that there isn't a group of attorneys that practice this outside of a big firm. So yeah, no, that's my understanding of healthcare law, is that's what my focus is.
Sure.
Grace, is it fair to say that if we did some more research on health law and we kind of reaffirmed that we don't think there's a market serving individual patients, that would satisfy that question, and you wouldn't be necessarily interested in a certification for those who are serving health hospital systems and the non-individual clients? I'd say, let me rephrase that. It seems like you're interested in health law if it is a specialty that could sufficiently be scoped around services for individual clients.
Yes, so if uh people in big law or big firms are not going to be the type to request the certification, I see George nodding. It sounds like then it becomes maybe the least practical of the three areas to focus attention on.
Mhm. Yeah, I think that's what we are seeing so far, just in this preliminary set of data that we could find out there. Yeah.
So do we want to gather some more information, maybe respond to that more?
Yeah, I think what we would like, what we were seeking today, maybe it's not entirely necessary, but we thought we could pass a resolution that says CBLS is going to direct staff to research these areas, and that we left that list blank. We could fill it in this meeting, so it could be George, your recommendation of consumer law and privacy law. It could be, excuse me, and personal injury law, or it could be all three. And Grace, we could come back and try to just answer that specific question about the feasibility of a specialty area on health law for individuals over firms or large entities. I guess that's up to the members to decide if you want to narrow this list down or if you'd like us to go and research all three. And I'll put the resolution up that we had proposed. It sounds like so far, definitely. Those two, and I guess the last question is whether to include healthcare law.
One more comment. Would all of these considerations be cost effective? I know there was a large discussion around budget, sunsetting one program and then absorbing the cost of another. So is that a factor, the cost, if there's any?
Well, we presented the exam related costs. So we need at the new fee that was set last year, we would need 35 individuals to take the test each exam to cover the cost of developing and administering an exam in the specialty in one of these specialty areas. And like we mentioned, 10 out of the 13 exams didn't have 35 test takers, so it is more difficult than it seems. We don't know the implications of the new fee, which is higher than the last exam's fee. That might bring numbers down. We don't know. So there are cost considerations, but we don't know. I don't think we could estimate now whether or not there would be negative or positive impact. We need, I think, a better sense of the interested population who would be interested in one of these specialty areas, and we might get a better sense of that when we talk to some of the groups and practitioners.
Where do the application fees go, or that is the certification fees? If I pass the exam, and then there's a fee for the specialization. Where do those fees go? To the program or to the state bar?
Yeah, the fees are like the exam related fees are related to the Office of Admissions because we administer the exam. The other fees are related to Mia's office and regulation. Mia, you've probably noticed I've avoided talking about any cost considerations for the other parts of the program because it's not my area. Do you imagine if we had a new specialty area, whether that means more costs for your office?
Possibly. I mean, it's hard to answer on the spot, but certainly, existing staff time, we'd have to make that assessment though. I mean, we currently have 3 full-time staff and one primarily dedicated to handling initial certifications. The other two primarily handle recertification applications. But we would have to, I think, make further assessment.
So, go ahead. Go.
Oh, go ahead, George. I'm sorry.
I was saying going back to the resolution, but let me. Do you want to say something?
No, I was just going to ask, are we comfortable passing a resolution? If the alternative is that we don't, and we just come back with research on these topics anyways, I think our intention of having a resolution is to really clearly demonstrate the kind of deliberate approach that's being taken, especially since as part of the new process, once a recommendation is made, we'll be bringing that to the board for their feedback. So we just really felt like it's important to indicate like the active decision making happening along the way. So if there is a decision made today, we'd like to document it with a resolution. If the members aren't comfortable with that, or there's too many unanswered questions, we don't have to do this. We could still come back at the next meeting or future meeting with that research, and seek a discussion or a recommendation at that time as well.
I'd like to move forward with a resolution with these two areas, and I think we can have further discussion on healthcare law in the future. And Grace raises some really valid points. I think it is an important area, but I do think we need to narrow the work for the staff and the board and focus things because of the amount of time involved. So.
I have a question. If it's looked into in the future or tabled, would it be like, what would be the horizon, like a year or two, potentially? Like the like privacy law took what, like 2 years or so? There,
Yeah, I think the way that we talked about trying to kind of formalize the process for CBLS to proactively introduce specialty area ideas, is that we talked about using the work plan at the beginning of the year as the opportunity to introduce new specialty area ideas, and then the CBLS could discuss at that time whether that should be a priority for that year. And then if so, then we have these types of discussions. So that's how we ended up with the work plan item that had these three examples. So as far as like being able to consider it again, I think the time horizon is probably next year with the next work plan. The other time horizon though, Grace, to your other point, if one of these areas really gets some legs and we're putting together a consulting group and we're really moving forward, then I think, there's CBLS at a future work plan discussion would probably need to weigh whether there's capacity to start working on another specialty area while developing a current specialty area. And then that's where it may turn into a multiple year time horizon where it might be more feasible to kind of wrap up one effort before starting another one. But this may not, any proposal here today may not be like at the consulting group development phase, by the next work plan. And so maybe maybe there's roadblocks that come up from our research, and it's worth revisiting at the next work plan discussion for the next term.
Let me ask, is there anyone that would like to make a motion to approve this resolution?
I will, Damon.
And I can second.
Okay, and Janelle, can we have a roll call, please?
Alano,
Aye.
Bennett,
Approve.
Jenkins,
Approved.
McGlory, absent, Rucker, absent, Surmitis,
Approve.
with four ayes and 0 nays, the motion passed.
Well, thank you, everyone, and thank you for that presentation and discussion. So that's the end of the open session items. There are no closed session items today. I want to thank everyone for attending today and remind you the next meeting is scheduled by Zoom on June 26, 2026 at 10 a.m. The current time is 12:24 p.m. and this meeting is adjourned.
All right. Thank you for your time.
Thank you.
All right.
All right, everyone. Take care. Have a good weekend.